Last year, my wife was misdiagnosed for having a miscarriage, and many weeks later, when she begged for an ultrasound, she was told that she was actually pregnant. So there was obviously negligence in that part, we were told. And then following on from that, she was supposed to have an advanced ultrasound because of the nature of her previous birth, which again was not done, which led to complications, and we believe that led to a premature birth of our little one. My question is that whether this can be combined into a lawsuit against the two different NHS trusts that was dealing with it. I've had a discussion with a legal director of a law firm regarding medical negligence, and his response was a bit discouraging. He mentioned that even though there is a no-win, no-fee, process in place, but a lot of the times you would have to bear the costs of the tests and testimonials from other medical professionals.
Sal, right. First of all, I feel bad for yelling "keep it short" at you. Can I ask you a few questions?
Yes.
Right. So I just want to make sure I've understood this. Your wife was told she'd had a miscarriage, but in fact she hadn't. She was pregnant.
Yes.
She then had an early birth. What week was the baby born at?
26.
Very, very premature then.
Yes.
Forgive me for asking this. Is the baby okay? Did the baby survive?
Yes, but not. He's not 100% well. He had to go through medical procedures.
Is he okay now?
Yes.
Okay, good. And what do you think would have happened if they had done the second scan, the one that they said they do but didn't?
So there is an advanced cervical scan that can detect abnormalities in the gestation, and with that, doctors can intervene and to make sure that to avoid premature birth.
Okay, so could the premature birth have been prevented if the correct diagnosis had been made?
We believe so.
You believe so based on medical input, or based on your research, or based on a hunch?
Based on our research and speaking to other doctors.
Okay. So this is quite serious. What was the reason for that second scan not happening?
We can't figure that bit out.
Did you try to make the appointment but were refused, or did something get lost in the system, or did you forget to make the appointment? What happened?
Okay. So the way it works is if the previous birth happens on a full dilation, then there is a advanced cervical scan which is normally offered, but that was not the case. We only found that out after everything sort of.
I see.
Went belly up.
So under normal procedures, under normal guidelines, you should have been offered the advanced cervical scan, but they just didn't do it.
Yes.
And had the trigger for that scan, forgive me, I think you said a birth at full dilation. I'm not quite sure what you mean, because of course all births are at full dilation normally.
So sorry.
I don't need the details, but was the trigger for that second cervical scan
if you have
definitely hit?
Yeah. Let me rephrase. If you have a cesarean birth at full dilation, then next birth can be tricky.
And is that what happened to your wife with the first birth?
Yes, she had a cesarean at full dilation.
So the trigger for this scan was definitely there?
Yes.
Right. Well, that does sound like negligence. There's quite a few hurdles you're going to have to overcome here to win a law claim, Sal. Number one is you're going to have to prove that the hospital was negligent in not offering that scan. But from what you're telling me, that sounds straightforward. You're also going to have to prove that having that scan would have picked up the problem that triggered the 26-week premature birth. Now, I don't know whether it would have done or not, and you'll need to get a consultant obstetrician to provide a report, or a radiologist to provide a report to give that information for a judge. And there's lots of ands here. You'll need to prove that even if that advanced cervical scan had picked up the abnormality that led to a premature birth, that something could have been done about it that would have resulted in a normal delivery or your baby not having those procedures when he was born. So there's several hurdles here. You're going to need expert evidence on those different hurdles. It is going to cost money. Now, the firm of solicitors you went to told you that you'll have to pay for the expert reports. They'll do no win, no fee for their fees, but not cover the expert reports. You can find solicitors or insurance policies that will cover everything for you.
Okay.
You'll just have to shop around a bit. The difficulty, Sal, I'm going to be really blunt with you. This is a horrible, horrible thing to say, but it's the way the law works. And what I'm going to say might upset you. Forgive me, but I'm assuming you'd rather I was honest than wasn't honest. Yes?
Okay. Yeah.
There's not a huge amount of money here at the end. There's no pot of gold at the end of the rainbow. If your 26-week-old son, or born at 26 weeks, had to have a number of surgeries, there will be compensation for him for pain and suffering. But for a young baby, it's not going to be a huge amount of money. And if there are no long-term effects, then there's no, and thank goodness there aren't, then there's no claim for lifelong loss of earnings, lifelong care needs, or anything of that nature. So there's a lot of hurdles to overcome to win, and I don't think there's a huge amount of money at the end of the litigation. But it's worth speaking to some other solicitors to see if they'll take it on a no-win, no-fee basis, even if this first firm wouldn't sell.